Can debt collectors still contact me after a cease and desist letter? If you are dealing with debt collectors and wondering about your rights, you might be curious if they can still reach out after you send a cease and desist letter. This letter is a formal request asking debt collectors to stop contacting you. Under the Fair Debt Collection Practices Act, once they receive this letter, they must cease all communication. This includes phone calls, emails, texts, and letters. However, there are a couple of exceptions. The debt collector can contact you one more time to confirm they received your request. They may also inform you if they plan to take further action, like filing a lawsuit. It is essential to understand that sending a cease and desist letter does not erase your debt. You still owe the money if the debt is valid. The letter simply stops the collector from contacting you directly. If the collector believes the debt is legitimate and you do not pay, they may decide to sue you. If you receive a lawsuit, it is crucial to respond to the court. Ignoring a lawsuit can lead to a default judgment, which may result in wage garnishment or bank account levies. From a bankruptcy perspective, sending a cease and desist letter can be a temporary measure to halt collection calls while you consider your options, including bankruptcy. Once you file for bankruptcy, an automatic stay goes into effect. This stay stops all collection actions, including lawsuits and most creditor communications. While the cease and desist letter offers some relief, it is not a substitute for bankruptcy. To send a cease and desist letter, use mail, preferably with a return receipt for proof of delivery. Some collectors might accept electronic communication, but mail is usually the most reliable method. If a collector continues to contact you after receiving your letter, except for the allowed exceptions, they are violating the law. You may have the right to sue for damages under the Fair Debt Collection Practices Act. You can also use a cease and desist letter to limit how a collector contacts you. For example, you can request to be contacted only in writing or at specific times. This could be helpful if you are negotiating a settlement but wish to avoid disruptive calls. In summary, a cease and desist letter can stop most contact from debt collectors, but it does not eliminate your debt or protect you from legal action. If you are considering bankruptcy, this letter may provide temporary relief, but the automatic stay in bankruptcy offers broader protection. Always keep records of your communications with collectors and consider seeking professional advice if you are unsure about your next steps.